still here on behalf of the Office of the State Attorney. Okay. Good morning, sir. Tell me your full name.
Andrew Davis.
Sir, you've been arrested on a warrant. There is no bond, according to the judge that signed the warrant, Judge Bain, and I will appoint the Office of the Public Defender to represent you. Thank you, sir.
Okay.
The next case I have is Alan Johnson.
Apologies, Your Honor. I'm pulling these because I just got them back. What did we do in Davis?
No bond.
No bond.
The next case is Alan Johnson. Tell me your full name, please.
Alan Etta Johnson.
Sir, you've been arrested on 2 charges, battery on a person 65 years of age or older and domestic violence battery. There is probable cause for your arrest. Is the alleged victim, present this morning? I don't see anybody. Have we heard from the victim in this case?
We have not, Your Honor.
Okay. Currently, you have no bond. I will set bond on both counts. Count 1 will be $1,000. Count 2 will be $1,000. We haven't heard from the alleged victim, so I'm going to set.
The victim is my mother, but you understand, son, look, this everything is, sir.
I'm going to set no contact at this time until we hear from your mother
Sir,
regarding whether
I don't
she
have her
wants to have
number, her phone
contact.
numbers. I don't
I
have phone
will
numbers.
appoint the Office of the Public Defender to represent you.
Your Honor, that was 1,000, count 1, 500, count 2.
1,000, 1,000.
Okay.
Next, I have Tony Williams.
How's this possible? I don't have that money.
Is the victim present on Tony Williams? I see nobody out there.
And we'll waive reading of the charges for Mr. Williams, Your Honor.
Tell me your name, Mr. Williams.
Tony Daniel Williams.
Okay. You've been arrested on charges. I read the police report. There is probable cause for your arrest. Currently, you have no bond, but you're entitled to bond, so I'll set bond in the amount of $7,500 with the condition you have no contact with the alleged victim in this case, and I will appoint the Office of the Public Defender to represent you. Thank you. Jeremy Franklin. Are you Mr. Franklin? Are you Mr. Franklin?
Yeah.
Okay. I show that you're charged with disorderly conduct. I will appoint the Office of the Public Defender to represent you.
Your Honor, I spoke with Mr. Franklin prior to court, and he indicated he would be interested in resolving the case. The offer is a withholding of court costs.
Okay. Sir, would you like to enter a plea of guilty to this charge and receive an agreed sentence? I believe that your client has competency issues based upon his last 2 responses.
Yes, Your Honor.
So I feel very uncomfortable taking a plea this morning. I will find probable cause. I'll leave bond set at $250 and ask that he be evaluated.
Yes, Your Honor.
Thank you. Next case I have is Richard Keller. Richard Keller? Okay.
He's also interested in resolving, Your Honor, just for the record.
State, what kind of criminal history do you have on Mr. Keller?
Your Honor, Mr. Keller has 3 prior DUI convictions, 1 prior open container conviction. Most of his convictions are traffic cases. He does have 1 prior petty theft with holds from 2018. Nothing too crazy, except the DUIs.
thought Mr. Wickstrom was the homicide on-call attorney, and Kelly was the backup.
I don't know. In training, she told us to always call her, so I called her. Well, texted, but yes. There was a moment of panic.
You, Mr. Keller?
Yes, sir.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please put your hand down. Tell me your full name and date of birth.
Richard Keller, 12/10/66.
You got a birthday coming up?
Yes, sir.
Okay. You've been arrested on petty theft, second degree. That's a crime that carries up to, is it a second degree felony?
It's a misdemeanor, Your
I
Honor.
don't know what petty.
Oh yeah,
theft
no,
is.
definitely misdemeanor.
Okay. So
I was
second degree felon, misdemeanor, punishable by up to 60 days in jail, $500 fine. Your attorney tells me you wish to plead guilty to this and receive an agreed sentence. Is that your understanding?
Yes, sir.
Okay. Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
Are you doing this then of your own free will?
Yes, sir.
As you stand before me now, are you under the influence of any drugs, medication, or alcohol?
No, sir.
Do you suffer from or have you ever been diagnosed with any mental illness?
No, sir.
I will find there's probable cause based upon the arrest affidavit. There should be a plea form in front of you listing all the rights you have and the rights you give up when you enter a plea. Did you read and understand that form?
Yes, sir.
And if you'll sign that, do you have any questions about those rights?
No, sir.
To the charge of petty theft, a second degree misdemeanor, do you plead guilty?
Yes, sir.
I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea. And I found a factual basis. State anything before I impose sentence.
No, Your Honor.
And defense, anything you wish to say.
No, Your Honor, and if I didn't
Thank you
announce
so
it
much.
earlier, it's an adjudication, court cost, and credit time, sir.
Mr. Keller, anything you wish to say.
No, sir. Thank you and appreciate you.
I will go ahead and adjudge you to be guilty, sentence you to, let me see if it's 2 days or 1 day. Looks like it's 2 days in jail with credit for 2 days you've already served. Order that you pay court costs, cost of prosecution, reduce that to a judgment. And I will order you not return to any Publix. So
Yes, sir.
shopping will not be a pleasure for you. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll
It was a misunderstanding. I just had a sandwich in the bag and I paid for the rest of it, you know, so.
and
Maybe them foreigners coming over taking our stores. Okay.
Have a nice day. Thank you. Okay, is Alan Knight next? You, Mr. Knight?
Yes,
Good morning.
good morning.
You are charged with trespass, failure to leave property upon an order by the owner. There is probable cause for your arrest. Bond is set at $500. In that case, I'll appoint the office of the public defender to represent you.
Your
There's-
Honor,
Yes,
could I be heard as to bond?
yes.
He was adjudicated incompetent and in Judge Dubois' courtroom, and
When?
he's out on conditional release
When?
in that case, October 25th of 2021.
Okay.
So we'd be asking for conditional release in this case.
I don't know that he still is incompetent. And so I'll ask you or your office, since I'm appointing you, to file the appropriate documents. In addition, there looks like there's a failure to appear for petty theft and a petty theft. I won't take, based upon what you just told me, I won't take any action on the 3 open, outstanding cases. But on this one, I will leave the bond set and ask you to file the appropriate motions to have him reevaluate to see if he's still incompetent.
Yes, Your Honor.
Thank you.
Thank you.
Next, I have George Maxwell. Tell me your name, please, Mr. Maxwell.
George Maxwell Jr.
Okay, you've been arrested on a charge of possession of drug paraphernalia. There is probable cause for that arrest and for open container. Does he qualify for pretrial release?
He does not, Your Honor.
Okay. There is probable cause for both. I'll appoint the public defender on both. The open container, I'll reduce the bond to $150. The paraphernalia, I'll reduce the bond to $150. And there's only those 2 cases, right? Or the 3? We have 2? Yes, only 2. Okay. Thank you, sir.
All right, yeah.
Next case I have is Ashrael Dennis. Tell me your name, please.
Ashrael Dennis.
Good morning.
Good morning.
Still good morning. You've been arrested for disorderly conduct. There is probable cause for that arrest. Bond is $250. I will appoint the office of the public defender to.
Your Honor, he has indicated he's interested in pleading to the case. The agreed upon disposition is a withholding court cost.
First, my understanding, you wish to plead guilty to this charge and receive an agreed sentence that I'm willing to go along with. Is that your understanding?
Yes, sir.
Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
Are you doing this then of your own free will?
Yes.
As you stand before me now, are you under the influence of any drugs, medication, or alcohol?
No, sir.
Do you suffer from or have you ever been diagnosed with any mental illness?
No, sir.
There is probable cause based upon the arrest affidavit in this case. Have you had a chance to read over and sign a plea form listing all the rights you have and all the rights you give up when you enter a plea?
Yes.
Do you have any questions about those rights?
No, sir.
To the charge of disorderly conduct, do you plead guilty?
Yes, I plead
Accept your
guilty.
plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I found a factual basis. State anything before I impose the agreed sentence.
No, Your Honor.
Anything you wish to say, sir?
I just have one question. I was trying to see if by pleading guilty I'd be able to be released today.
Yes,
Okay, that's all.
that's a good question. I will go ahead and withhold adjudication of guilt, sentence you to 2 days in jail with credit for 2 days you've already served. Order that you pay court costs, cost of prosecution. I will not appoint the public defender in the case, so there'll be no fee, and I'll reduce it to a judgment. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll appoint one for you. Good luck to you.
Thank you.
You're welcome. The next case I have is Junior Lewis. Sir, tell me your name, please.
Junior Lewis,
You've been charged with trespass in an occupied structure. There is probable cause for your arrest. Does he qualify for pretrial release?
He does, Your Honor.
Okay. I'll release you into pretrial release, and I'll appoint the office of the public defender to represent you. Thank you.
Your Honor, he has also indicated he would like to plead to this case.
There's a victim in this case because it's a trespass, so I don't believe I can take a plea under Marcy's law without input from the victim.
Okay, thank you, Your Honor.
Thank you. Next, I have Michael Lucchesi. Good morning, sir.
Morning.
Tell me your full name, please.
Huh?
Tell me your name.
Michael Joseph Lucchesi.
Mr. Lucchesi, you've been arrested on a charge of battery on a law enforcement officer, destruction of evidence, possession of paraphernalia. There is probable cause for your arrest. Bond in count 1 was $2,500. I'm going to reduce that to $1,500. Count 2 is $150. Count 3 is $100. I'll appoint the office of the public defender to represent you. Thank you, sir. The next case I have
Your
is,
Honor,
yes,
Mr. Lewis, the trespass that you did PTR, did you want any conditions with that?
that he not return.
No return? Okay.
Yes, thank you. I have Ashley Poindexter. Refusal? Okay, let me appoint the office of the public defender. You wish to waive your client's presence?
Yes, Your Honor, and if I may, she also was adjudicated incompetent to proceed in front of Judge Wilson.
When?
So we'd ask for mental health pretrial release if possible.
Sorry, when?
When was she adjudicated?
When was she determined to be incompetent in front of Judge Wilson?
Let me check. So she's been incompetent to proceed since August 13th of 2020.
Okay. So I will find probable cause. I'll set bond at $250. And based upon finding probable cause, I'll revoke the bonds in 2020 CF 333 and 2018 CF 12221. And now that it'll be back in front of the judge, she can go ahead and order updated evaluations because what you have would be stale. It appears from reading the police report she may still be, but I'd like to get an updated one. Thank
Mr.
you.
Mayor.
Next, I have Raphael Shirley. That was a behavior yesterday.
She refused.
Okay. I'll appoint the office of the public defender. Would you waive his presence?
Yes, Your Honor.
I will find probable cause, set bonding amount of $500, order that he not return to the location where this occurred. Behavior. Okay. No contact. The next case I have is Timothy Childs. Finally, what's your name?
Timothy Joseph Childs Jr.
Okay, sir, you've been charged with 2 separate offenses, aggravated assault, domestic violence, and battery domestic violence. There is probable cause for each of these charges. If we had contact with the victim?
We have not, Your Honor.
Okay. I will go ahead and set bond in both of these counts since the Constitution and our statutes indicate you're entitled to bond. Bond in count 1 is $2,500, count 2 is $1,000 with the condition of no contact with the victim in this case until we hear from the victim and no return to the location where this occurred. Having found probable cause, I will revoke your bond in 2021 CT 1050, the DUI charge, and set bond at 0. Next case is Lysandra Harrison.
Your Honor, did you appoint the public defender in that case?
I did not, but I will.
Okay.
Okay, tell me your full name, ma'am.
Lysandra Harris.
Sandra Harrison, you've been arrested on a charge of aggravated assault, dating violence. I've reviewed the report. There is probable cause for your arrest. Is the victim present? Have you heard from the victim?
We did not, Your Honor.
Okay, I will set bond. Currently, you have no bond. I'll set bond based upon the allegations in the amount of $5,000 with the condition you have no contact with the victim in this case. You not possess any weapons or firearms. I will appoint the office of the public defender to represent you. Actually, I will not appoint the office of the public defender to represent you since you do not qualify. The next case I have is Felicia Mayoral.
You have a bond, so you can bond out.
Tell me your name, please.
Alicia Mayoral.
Ma'am, you've been arrested on 3 separate charges: tampering with the witness, domestic violence battery, and battery on a person age 65 years of age or older. Is the victim here? Have you heard from the victim?
We have, Your Honor. They did not plan to attend initial appearance today, and she does qualify for PTR.
And what about contact? Anything?
It looks like they did not want contact.
Okay. I will go ahead and release you on pretrial release and order that you have no contact with the alleged victim and that you not return to the location where this occurred. And I will appoint the office of the public defender to represent you. Thank you. The next case I have is Caleb McLaughlin. Tell me your name, please.
Caleb McLaughlin.
Sir, you're charged in 2 separate cases. The first one is battery, domestic violence by strangulation, and battery. The second charge is a violation of probation. In the battery and battery by strangulation, there is probable cause. Is the victim present? Ma'am, would you please raise your right hand?
Do you solemnly swear and affirm the testimony you're about to give should be the truth and the truth to help you God?
I swear.
Please state your name for the record.
Abigail Bertley.
And Ms. Bertley, you're the alleged victim in this case. I'm about to set bond because he's entitled to bond. My question is, are you concerned for your safety?
No, I'm not.
So if I order that he have contact but not hostile contact, are you comfortable with that?
Yes, I am.
Sir, can you follow that order?
Yes, sir.
Okay. Hearing from the alleged victim in the case, I will go ahead and set bond in this case. Does he qualify for pretrial release?
He does not, Your Honor.
I'll set bond count 1, $1,000, count 2, $500 with the condition of no hostile contact. In the second case, violation of probation, we're going to hold you on no bond since you've been arrested on a new offense. And it appears you do not qualify for a public defender, so I will not appoint the office of the public defender. Thank you. Thank you, ma'am, for coming this morning. The next case I have is Andre Reed. Is the victim in Andre Reed present? And Have we heard from the victim and Andre Reed?
We have, Your Honor. They did state that they were in fear of the defendant.
Okay. Sir, please tell me your full name. Sir, you've been arrested for aggravated assault, domestic violence. I've read the police report. There was probable cause for your arrest. Currently, you have no bond. You're entitled to bond, so I'm going to set bond in this case in the amount of $2,500 with the condition you not have any contact with the alleged victim until I modify that order, you not possess any weapons or firearms, and you not return to the location where this occurred. I will appoint the office of the public defender to represent you. Thank you, sir.
Sir.
This case I have is David Rivera. Is the victim and David Rivera present? Seeing nobody, have we heard from the victim and David Rivera?
We have not, Your Honor.
Okay, sir, please tell me your full name.
David Alexis Rivera.
Eggs David, okay, I apologize.
Yes, sir.
I probably am not the first person to read it dyslexic.
Everybody get my name.
You should speak to your parents about that.
My dad named David.
Okay, that's why.
My mama name starts with an X, so she just took the X and put the she took the D out and put the X in.
It is unique.
I like
Okay.
it.
You've been arrested on a charge of child abuse. I've read the police report. There is probable cause for your arrest. Currently, you have no bond, but you're entitled to bond by law. So I'll set bond in the amount of $3,500 with the condition you have no contact with the victim or the family of the victim. I will appoint the office of the public defender. Does he qualify for pretrial release?
No, Your Honor.
Okay, thank you. Next case I have is Sean Thomas.
Thank you so much, Your Honor.
Yes, sir.
God bless you.
Thank you. Sir, tell me your full name.
John Dwayne Thomas Jr.
Okay. And ma'am, would you please raise your right hand? The clerk's going to place you under oath and ask your name.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Please state your name for the record.
Chevelle Armstrong.
Okay. You are listed as the alleged victim in this case. Currently, there's no bond on both these counts, but Mr. Thomas by law is entitled to bond, so I'm going to set bond. My question for you is, are you in fear for your safety or well-being?
No, that's my
So if
fiance.
I order that he can have contact but not hostile contact, you're comfortable with that?
Yes.
Okay. Can you follow that condition, sir?
Sir.
Okay, I'll set bond in count one in the amount of $1,500, count two, $500, with the condition you have no hostile contact, unless he qualifies for pretrial release.
He does not, Your Honor, and before court, an out on bond case was found in 2021 MM 008481 AO for a trespass that he is out on bond on.
Okay, I'll take no action on that at this time.
Sure. It's 2021 MM 008481 AO.
Sir, did you understand everything?
Yes, sir.
Okay, thank you.
Your Honor, did you make a finding of probable cause?
And if I didn't, I will find probable cause.
Are you not appointing the public defender?
And I'll appoint the office of the public defender. Did I miss all that? Okay, Madam Clerk has it. Okay, next case I have is Daniel Osorio Maya. Is that you?
Yes, sir.
Good morning. You've been arrested on a charge of battery, and you currently have no bond. The statutes and Constitution indicate you're entitled to bond. Sir, would you please raise your right hand?
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Please state your name for the record.
David Osorio.
Okay, sir, you're the alleged victim in this case. As I indicated, Daniel's your father, is that correct?
Yes, yes, sir.
He's entitled to bond, so I'm going to set bond. My concern is for your safety and well-being based upon the allegations. Are you concerned about your safety and well-being?
No, I'm good.
Pardon me?
No, sir.
No, sir. Okay. So if I order that he not have hostile contact with you, which means he can't raise his voice, he can't touch you, he can't threaten to touch you, are you feel safe with that?
Yes, sir.
And how old are you?
18.
Okay, thank you. Does he qualify for pretrial release?
Yes, he does, Your Honor.
Okay. I will go ahead, having found probable cause, appoint the office of the public defender, release you on pretrial release with the condition you have no hostile contact with your son, if you can follow that condition. Can you follow that condition?
Yes, Your Honor.
Okay, thank you. Next case I have is Raylene Prieto. Have we heard from the victim in Ms. Prieto's case?
We have not, and she does qualify for PTR.
Okay, thank you. Ma'am, tell me your full name.
Raylene Prieto.
You've been arrested on a charge of dating violence battery. There is probable cause for your arrest. I'll appoint the office of the public defender to represent you. You currently set at no bond, you're entitled to bond, so I'm going to release you into the pretrial release program with the condition you have no contact with the alleged victim in this case, and you not return to the location where this occurred, only if you tell me you can follow those conditions. Can you follow those conditions? Thank you. Next case I have is Daniel Rivera. Have we heard from the victim in Daniel Rivera? Hold on one second.
We have, Your Honor. They didn't talk about contact. They just said that they would not be attending court.
Okay. Sir, please tell me your full name.
Excuse me?
Tell me your, tell me your full name.
Giles.
Thank you. Okay.
I can hear very good.
I can't either.
You can?
I can't either.
Daniel Giles.
No, I heard that, but generally speaking, I can't either. I was just commenting that you and I share the same malady.
Okay.
You've been arrested on a charge of domestic violence battery. Currently, there's no bond, but you're entitled to bond by law. Does he qualify for pretrial release?
Yes, he does, Your Honor.
Okay, I'm going to release you in pretrial release. You should be released today with the condition you have no contact with the alleged victim. Okay? No contact with the victim. And I will not appoint the office of the public defender in this case. Did you understand what I said?
Yes, I have a question. Where the lady live, it used to be my apartment, and she just took over the lease, and all my belongings, 2 cars, TVs, all the stuff that is inside.
I'll take care of that. I'll give you an opportunity to return to your apartment with assistance of law enforcement to obtain your possessions.
Okay.
Okay?
Perfect. Thank you very much.
Your Honor, I believe you issued no contact with the victim. Could you also issue no return to the scene except for the one-time
I
return?
issued no return, and I'm
I'm
now
sorry.
giving him the one-time return. Thank you for clarifying that.
So,
No return, he can return one time with the assistance of law enforcement to gather his belongings. Okay. Tell me your name, please.
Jean Rivera.
Good morning.
Good morning.
Actually, good afternoon, sorry. You've been charged with domestic violence battery. Have we heard from the victim in this case?
We have not, Your Honor. She does qualify for PTR.
Thank you. I will find that there was probable cause for your arrest in this case. I'll release you into the pretrial release program with the condition you have no contact with the victim in this case if you tell me you can follow that condition. Can you follow that condition?
Yes.
Okay. I will appoint the office of the public defender to represent you,
Your Honor, we would also request a no return to scene in this case.
and I'll also order that you not return to the location where this occurred. Thank you, Ms. Allen. Next case I have is Garrett Shin. Tell me your name, please.
Garrett Sheehan.
Good morning.
Morning.
And somebody has shown up here. If you'll place him under oath.
can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Gary Huff.
Okay. Sir, you're the alleged victim in this case. I've reviewed the report. There is probable cause for the arrest of Mr. Shin. Currently, he's set for no bond, but the statutes and Constitution indicate he's entitled to a bond. My concern is for your well-being. Are you concerned for your well-being or safety of yourself or your family?
I saved myself and my family, and I would like to ask the court to issue emergency custody for my kids, my daughter's kids, and that way he can't get to them, and also so that he will stay away from us. We just got down here yesterday on our family vacation for Christmas, and it happened last night.
Okay.
And we're going to be down here. I don't know where he's going to go, but we don't need him at the condo.
So I'm going to make it a condition that he not return to that location and have no contact. If she's seeking emergency custody, she needs to go to the courthouse on the 5th floor and file a petition for that. At this hearing, I don't have the authority without the petition to grant that, but I will issue a no contact at all order. So if he does have contact or attempt to have contact, you can call the police and he'll no longer be entitled to a bond.
And he still does have a suitcase there at the condo. If somebody security can come by and
I'm going to let him return one time with law enforcement by his side in order to avoid any conflict.
yeah, I'll be good. I mean, I'll be willing to drop the charges if he can just stay away and we can grant it.
That's between you and the state, but it's really the state that goes forward on the charges.
All
But I've heard everything you said. Is there anything else you wish to say to me?
Is there any way we can move this trial to North Carolina since we was just down here on vacation?
Is there any way you can go to North Carolina?
Is there any way we can have the rest of this trial in North Carolina?
There is not.
Okay. Thank you, sir.
It's a good question, but we cannot do it that way.
Okay. Thank you.
Okay. Sir, you've been arrested on battery, domestic violence. There is probable cause for your arrest. You're entitled to bond, as you heard me say. So I will set bond in the amount of $500 with conditions that you not return to the location except once with the assistance of law enforcement to obtain your suitcase. Can you follow that condition?
Sir.
That you not have any contact with the alleged victim or her family or her children, and that you not possess any weapons or firearms. I won't appoint the Office of the Public Defender to represent you. Thank you, sir. Thank you.
Thank you, sir.
This case I have is Zariah Tucker. Tell me your name.
Exaria Tucker.
Okay. Good afternoon.
Good afternoon.
You've been arrested on a charge of domestic violence, battery, and criminal mischief. There is probable cause for your arrest. Currently, you have no bond in count one, $250 in count two. You're entitled to bond in count one, so I'm about to set that, but we have a gentleman here. Would you raise your right hand for me?
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Wogan Scolis.
Sir, this is your opportunity to tell me, since she's entitled to a bond, if you're concerned for your well-being or safety.
None at all, sir.
So if I indicate that she should have no hostile contact with you, you feel safe in that, correct?
Yes, sir.
Okay. Can you follow that instruction if I order that?
Yes, sir.
And does she qualify for pretrial release?
She could, Your Honor, yes.
Can I add something, sir?
Yes.
I just want to say we've been through a lot, and we currently trying to find a place to stay. And I still want to look forward to that. As I told the deputy from last night that I don't want to press charges. I want all case to be dismissed.
I totally understand that, except for it's not up to you to decide to press charges. It's up to the state of Florida. It's actually written in the report, your statement, plus Ms. Allen, the prosecutor, is making notes of that, and they'll take that into consideration, okay?
Yes, sir.
Thank you.
Thank you.
Ma'am, I'm going to release you into pretrial release and on both counts. So there's no monetary obligation. You should be getting out today
Yes, sir.
with the condition of no hostile contact with this gentleman. Because you told me you can follow that condition, I will appoint the Office of the Public Defender to represent you. Thank you. This case I have is Paul Wilson. Is that you?
Yes, sir.
Good morning. Good afternoon.
Morning.
You've been arrested on a charge of domestic violence. Is the alleged victim present? I see no one else present. Have we heard from the alleged victim?
We did, Your Honor. I don't have any further information about contact, and he does qualify for PTR.
Okay. So you've been arrested. There is probable cause for your arrest. I'll appoint the Office of the Public Defender. Currently, you have no bond. You're entitled to bond, so I'm going to release you into the pretrial release program. So there's no monetary obligation. But there's a condition that you have no contact with the victim in this case, because we have not heard from the victim, that you not return to the location where this occurred, and you not possess any weapons or firearms. Can you follow those conditions?
Yes, sir.
Okay, thank you.
Thank you.
The next case I have is Jose Acevedo Boria. That you?
How you doing, sir?
I'm doing fine, thank you. You've been arrested on a charge of grand theft motor vehicle, possession of cocaine, possession of paraphernalia. There is probable cause for your arrest. And I will appoint the Office of the Public Defender to represent you. Does he qualify?
He does not, Your Honor.
Okay. Your bond in count one is $1,000, count two is $150, count three is $100. Thank you. Frederick Anderson. Good morning, good afternoon. You've been arrested on a charge of false imprisonment, assault, and battery. I've read the police report in your case. And you're also arrested on possession of firearm in the commission of a felony, possession of ammunition by a convicted felon, and possession of a firearm by a convicted felon. There is probable cause for all of these charges. Bond is set for false imprisonment of $3,000, $250 for the assault, $500 for the battery, $5,000 for possession of a firearm and commission of a felony, The ammunition charge, $150, and the firearm by convicted felon, $150. I will appoint the office of the public defender to represent you and make it a condition of your release. You have no contact at all with the victim in this case. Thank you. And the next case I have is it LeGrand Birdsong? What's your name? Pardon me?
Sir.
Okay. You've been arrested on a charge of grand theft motor vehicle. There is probable cause for that arrest. Bond is set in the amount of $1,000. Having found probable cause in case number 2020 MM610, I will revoke the bond and set bond at $0. Appoint the office of the public defender to represent you in both cases. Thank you.
Your Honor, could you read out the one you revoked bond on?
The case number or the charge?
Case number.
I did. I'll do it again.
I'm sorry. Yes, I was asking you to repeat
Speak
it.
quickly. It's not a problem. I have 2020 MM610AW.
Thank you, Your Honor.
Okay, the next case I have is Donovan Daniels.
You did not appoint the PD, right?
I did.
You did?
Yeah.
Okay. Sorry, he has a private on the other one, so I just wasn't sure.
You ready?
Yes. I'm sorry. I'm writing as fast as I can.
You're fine. And tell me your name, please.
Donovan Daniels.
So you've been arrested on a charge of possession of fentanyl, resisting without violence, and panhandling, and failure to appear. There's a warrant for your failure to appear. The bond on the failure to appear has already been set at $500. I'll appoint the office of the public defender in that case. On the 3 new charges, bond is set at $1,000 on count 1, 100 count 2, 100 count 3, and I'll appoint the office of the public defender to represent you as well.
Your Honor, may I be heard as to the possession of fentanyl case?
Sure.
It wasn't indicated in the affidavit that the fentanyl was tested, so we don't know if it was.
Well, he said it was K1, and then I was looking for that too. Give me a second. Donovan complied to answer questioning and stated the 3 baggies contained fentanyl. So we're only dealing with probable cause. So
Yes, Your Honor.
I was concerned about that as well, but
Yes,
when I
Your
saw that statement, I'll take his admission as a statement against his interest. Thank you.
Thank you, Your Honor.
Okay. Francis Guerin.
And we'll waive reading of the charges, Your Honor.
Hey, tell me your name, please. Tell me your name, please.
Aaron Francis.
Okay. You've been arrested on a cornucopia of charges. I will appoint the office of the public defender to represent you. She has asked that I not read the charges. Currently, no bond has been set on all 6. Are there 6 or 7? You have 6. I have one more in the second.
Your Honor, there are 6 charges on the first page, and on the second page, we have capital sexual battery as a separate charge.
Okay, so there's actually a total of 7, and and the judge already found probable cause. I think that was Judge Saunders. And you have no bond in each of those counts. I will appoint the office of the public defender to represent you. Thank you. Next case I have is Jonathan Zicki,
Bonded, Your Honor.
as he should have. The next case I have is Buster Gordon.
You have a booking number for them, Your
I
Honor?
do. I have 21028-173.
They bonded.
Bonded. Next case I have is Vandris Hannett. Are you Mr. Hannett?
Sir.
Good afternoon.
No.
You've been arrested on a charge of possession of methylene dioxymethamphetamine, commonly referred to as ecstasy, possession of cannabis, resisting without violence as probable cause for your arrest. Does he qualify for pretrial release?
He does not, Your Honor.
Okay, I'll set bond in count 1 in the amount of 1,000, counts 2 and 3, 100 each. I will not, Miss Allen, appoint the office of the public defender to represent you. So you have bonds of 1,000, 100, and 100. You understand?
Yes, sir.
Okay, thank you. Next, I have Darius Hood. Tell me your name.
Darius Hood.
Been arrested on a charge of CCF, carrying concealed firearm. There is probable cause for your arrest. Your bond is $1,000. Does he qualify?
He did not, Your Honor.
Okay. I'll leave it at 1,000. I'll appoint the office of the public defender to represent you. Thank you. Emya Howard. Howard. Emya. Tell me your name, please.
Emaya Howard.
You've been arrested on a charge of grand theft third degree, possession of anti-shoplifting device, resisting a merchant, resisting without violence. There is probable cause for your arrest. Bond in count 1 is $5,000. I'm increasing bond in count 2 to $5,000. Count 3 is $200. Count 4 is $200. I'm going to order as a condition you not return to the Mall of Millennia property, and I'll appoint the office of the public defender to represent you. Thank you. Next case I have is Christopher George. I've got 3 cases.
You have a booking number for them, Your Honor?
Is it Jackson, Your Honor?
Yeah.
George Christopher Jackson?
George, oh,
Oh, it's George Jackson. I'm sorry. George Jackson. Okay. Tell me your name, sir.
George Jackson.
Okay. I had renamed you Christopher George, but we'll go back to George Jackson. You've been arrested on a charge of driving while license suspended or revoked. That's funny. I've got a citation for that, but not a police report for that. There it is. So that's count 2 and grand theft motor vehicle. There is probable cause for your arrest. Bond is $1,000 in count 1, 100 in count 2. I'll appoint the office of the public defender to represent you. And it appears you were on probation. And so I'm holding you on no bond on the first violation of probation. And then you're on probation on another case, also out of county, and I'll hold you on no bond. Same one?
Same.
Just a repeat? Okay. So I'll wholly hold you on no bond on one of those violations of probation. I will appoint the office of the public defender to represent you on both cases because I don't want you sitting in our jail and not getting transported if you bond out on the grand theft charge. Thank you. Janine Jackson. Tell me your name, please.
Keenan Johnson.
Okay, Keenan. You've been arrested on a charge of destruction of evidence. It's a warrant for your arrest. Bond was already set at $500. I will appoint the office of the public defender to represent you. Thank you.
and it was at 500 or PTR, Your Honor. He didn't qualify for PTR. Could you just strike the PTR part of it?
Okay, strike the PTR part of it. Any other
Your Honor.
requests?
Just that.
Thank you. Jeffrey Klein, please.
No call.
Okay, Ronnie, can I ask you a question though?
Yes, speak nice and loud.
Okay, so I was when I got the destruction of evidence, I was told that I was supposed to get a letter in the mail 2 days ago. I never got the letter in the mail, so I'm trying to figure out why did it go into warrant.
What kind of letter in the mail?
It was supposed to be a scheduled court date for me to see you, and I had a warrant. It was 2 days ago. I never got no letter in the mail or a phone call. That was 2 days ago.
Okay, so I've got an affidavit for arrest warrant dated December 3rd, which would be 2 days ago, technically, right?
Mm-hmm.
And that was presented electronically to me, and I signed it on the same day. And so I don't know what letter you were speaking of. Since the law enforcement officer presented a warrant to me, I found probable cause. What was the letter? The letter supposed to have a court date on it?
He told me that I would get a letter in the mail, and he told me that I'll have a court date that I have to arrive to appear to. It will come in the mail or we'll call your phone. I never got none of that. I just
Right.
had a warrant put on my name.
I don't know who said that or why that person said it. So it's a good question, but I don't have the answer for you. I don't understand how that happened.
Another thing is, I have money to bond now. It's just my mom is in another state. I'm not eligible for pretrial because of that reason. Because I would pay the bond, but I don't have nobody to sign for me state.
And he does not qualify for pretrial release, correct?
No, he did not, Your Honor.
Okay. You don't qualify for pretrial release. If you qualified, I would have let you out on pretrial release. In fact, my warrant indicated pretrial release or
Yeah, the lady downstairs, I talked to her.
if you don't qualify for it.
I don't know why she told me I did downstairs.
I don't know why she told you did either. I'm in a courtroom and you do not qualify.
May I know the reason why I don't qualify?
Do we have a reason?
Yeah, it looks like we were trying to verify some community ties, and the individual we reached to try to verify them with didn't have any information on his whereabouts. I don't think he had not a stable address that he's living at right now. So we weren't
collision.
able to verify any ties to the community.
I do have a stable address. It's the collision.
Okay. I'm not here to make that determination. Pretrial release, it's their program. They weren't able to verify it. I'm not going to release you on pretrial release unless you qualify. You do not qualify.
Your Honor, for the record, I would just like to correct his name. He's booked in Orange County Jail under Keenan Johnson. The arrest affidavit has him as Keenan Jackson. So whichever is correct, can we get that fixed?
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Okay. Tell me your full name.
Keenan Mershad Johnson.
Johnson. Okay. That's what we have on our paperwork. So we're okay.
Okay.
Okay. Thank you. Jeffrey Klein.
I don't know how I'm not eligible.
Tell me your full name, please. Good afternoon.
Hello.
You've been charged with burglary of a conveyance and grand theft. There's probable cause for those arrests. Bond is $3,500 count 1, $150 in count 2. Does he qualify for pretrial release?
He does not, Your Honor.
I will appoint the office of the public defender to represent you. Thank you.
Is there any way I can have like or?
No.
Your Honor, this was Jeffrey Klein, correct?
Next case I have is Riley Liberty.
She bonded.
Next case, I keep saying that. Basilio Matias.
Yes, sir.
Okay, good morning, good afternoon.
Good afternoon, sir.
You're charged with petty theft. There's a warrant for your arrest, and the bond has already been set at $1,500. I will appoint the office of the public defender to represent you. Thank you.
Okay. Thank you, sir.
Yes, sir. Oh, hang on. There's conditions. What conditions? Strobridge said no contact with the victim. Yeah, let's bring him back in. I was trying to make notes of that earlier since you were pointing it out yesterday. I was trying to catch up on that. Boy, you must have run out of here. Here we go. Judge Strobridge added conditions to your bond of $1,500 that you not have contact with the victim and you not return to the scene. So those are conditions of your release. I just wanted you to know that. Thank you.
I understand, sir. Thank you.
Thank you.
Thank you, man.
This case I have is Darlene Romero.
Your Honor, may
Pardon me?
Hospital.
Hospital. And you wish to, if I appoint the office of the public defender, will you waive her presence?
Yes, Your Honor, and I also have a probable cause challenge.
Okay, I will appoint the office of the public defender. Her presence is waived. I reviewed the arrest affidavit in this case, and you may argue.
Yes, Your Honor. For the possession of a firearm by a convicted felon, there's no allegation that she's been convicted of a felony in the report.
I was looking at the first part of it first, and then I finally saw where the neighbor said that it happened. So let me look at the conviction part. This was the one with where she jumped in a car, correct?
I believe so, Your Honor.
Okay. Well, you know, Interestingly enough, in 2021 CF 2362, she's charged with possession of ammunition by a convicted felon. But I don't see where it's written in this report for me to make that finding. State, am I missing something on the affidavit? Which I might be, I just didn't see it. I think Mark Barrios just overlooked that part.
Your Honor, it does not explicitly say that they ran a search and discovered that she was a convicted felon. However, if the state may make an offer of proof she is in fact a convicted felon, I can read you the case numbers and adjudications if the court would permit.
Well, I don't have sworn evidence or information of that, right?
Well, Your Honor, the officers, though it is conclusory to say that she was placed under arrest for possession of a firearm by a convicted felon, I believe that we can read between the lines to find that they did do a search and discover that she was in fact a convicted felon.
Maybe we can, but I'm not going to. So I can either find out probable cause for that count, or I'll take any other action you might ask for.
Your Honor, we would request that you reset this 24 to 48 hours to give us time to request the officer and make a supplemental report.
Okay. I'll make a finding of probable cause for the firing a weapon in public or on residential property. I will give the state 48 hours until noontime on Pearl Harbor Day to present probable cause. And based upon my finding of probable cause on count 2, I'll revoke the bond in 2021 CF 2362, revoke the bond in 2021 CT 1597, revoke the bond in 2021 CF 4019, and I will appoint the Office of the Public Defender. Thank you. No PCs to count 1, and giving the state 48 hours. PCs to count 2.
Okay.
You're keeping the bond at 100?
Yes.
Okay.
Anything else?
Nope, not for me.
Next, I have Jonathan Torres. Is that you?
Sir.
Good morning. Good afternoon.
How you doing?
I'm doing fine, thank you. You've been arrested on a cornucopia of charges: grand theft motor vehicle, burglary of a conveyance, aggravated battery with a deadly weapon, burglary with an assault or battery, resisting officer with violence, resisting officer without violence, and battery on a law enforcement officer. I reviewed the police report in this case. There is probable cause for your arrest, and your bonds will be set as follows. Count 1 is set at 1,000, count 2, 150, count 3, 150. Count 4 is a life felony, so you're entitled to no bond on that. Count 5, 100, count 6, 100, count 7, 100. Based upon your new arrest in case number 2021 CF 6876, I will revoke your bond and issue no bond in that case, and I will appoint the Office of the Public Defender to represent you. Thank you.
Okay. All right.
That was a lot. Next is Brittany Woods. Tell me your name.
Brittany Woods.
You've been charged with aggravated battery with a deadly weapon and possession of paraphernalia. Have we heard from the victim in this case?
We have not, Your Honor.
Okay. There is probable cause for your arrest. I will appoint the Office of the Public Defender to assist you, and I'll set bond, I'll leave bond in the amount of $3,500 count 1, $500 count 2, unless she qualifies for pretrial release. Does she?
She did not, Your Honor.
Okay. Thank you, ma'am. Continuing on, Erwin Dedios.
Yes, sir.
Okay. Good afternoon. You've been arrested on a warrant for failure to appear. That bond was already set at $500, so we'll leave that set. Also on trespass on property after warning, there's probable cause. Oh, so it's 500 or mental health, pretrial release?
Yeah, on the
Okay. So it's $500 or a mental health pretrial release.
That's for
And-
the trespass, Your Honor.
Pardon me?
Is that for the trespass or the?
No, that's for the failure to appear.
Yeah, okay.
Thank you for clarifying that. Next, the trespass on property after warning bond is $500. I'll make it $500 or a mental health pretrial release as well. So if you qualify for that on both charges, you can be released. I will appoint the Office of the Public Defender to represent you. Thank you, sir.
Thank you.
Your Honor, just to clarify, the mental health pretrial release is only for the failure to appear. Bond is still $500 for the trespass?
No, it's on both.
Okay.
I thought I'd make it consistent. And so if he qualifies, he can get out on both. Okay, the next case I have would be Corey Wendell. Is that you?
Yes, sir.
Good afternoon.
Good afternoon. How you doing this morning?
I'm doing fine, thank you. Looks like you were arrested for DUI and driving while license suspended or revoked. There is probable cause for those arrests. Does he qualify for pretrial release?
Yes, Your Honor, he does.
Okay, I'm going to release you into pretrial release with the condition you not operate a motor vehicle without a valid license. Can you do that?
Yes, sir. I
And
made a stupid decision, and I know that.
okay, I will appoint the Office of the Public Defender to represent you. Thank you.
And that's on both the DUI and the dwellers?
Yes, ma'am. I have Stephanie Collins. Are you Stephanie Collins? Yes? You've been arrested on a warrant charging you with failure to appear. That judge set the bond in the amount of $500. I will appoint the Office of the Public Defender to represent you.
Okay.
You've also been arrested, it appears, for making a false report, giving false information, and resisting without violence. Probable cause for each of those charges, and bond is $500 on each of those charges. I will also appoint the Office of the Public Defender to represent you in that as well. Thank you. Next case I have is Farrington James.
Your Honor.
Yes.
There was a proposed resolution for both counts on that and the driving while license suspended,
Is that the
which I
case where the warrant was, the driving?
believe created the failure to appear.
Okay.
If she wishes to resolve those, I think that might be what the public defender is discussing.
Your Honor, she wishes to resolve both cases.
Okay.
It's in court costs, Your Honor.
Yes, Your Honor. For the record, in case number 2020 CT 323AW, driving while license suspended, the state's offer is a withhold in court costs. In case number 2021 MM 804AW, the state's offer on count 1 is a withhold in court costs. On count 2, resisting without violence, the state's offer is the pretrial diversion video, or a withhold in court costs, but the video is about 45 minutes.
For the resisting without?
Yes, Your Honor.
Okay. You trying to keep me here past 1 o'clock?
No, Your Honor, but it's looking that way.
How you doing?
Your Honor, I have a question not related to this. When someone bonds out, does that mean they're released ROR or PTR? Or does it depend?
They bond out?
Yeah.
You mean by paying money?
Yes.
They're released on bond.
So it's neither.
It's neither of those.
I don't have a stack for neither. Thank you.
So you can be released on bond, on pretrial release, or on ROR.
Okay.
Those are your 3 options.
Got it.
That means jeez. Yeah, this has someone can get me right now.
Yes, exactly right.
Get me right now.
During this lull, we should point out that every male in this courtroom has the fashionable haircut this morning.
Oh, your favorite.
So do I have to find out what you're saying?
I don't think so. Sorry about that, Your Honor. She's
problem.
just going to go ahead and.
No problem. If it worked out, it would have been fine. Next, tell me your name.
Farrington James.
Okay, what happened to Farrington James? You're Farrington James? Okay. And what's your date of birth?
10/4/93.
Perfect, okay. You're charged with driving while license suspended or revoked. There is probable cause for your arrest. Does he qualify?
Yes, he does, Your Honor.
I'm going to release you into pretrial release with the condition you not operate a motor vehicle without a valid license and appoint the office of the public defender, okay? Thank you.
It's here. Yes, sir.
Thank you.
Next case I have is Robert Maples. Okay, doing fine. You are charged with failure to appear. There's a bond already set for $100 in that case for no vehicle registration. I will appoint the office of the public defender to represent you on that case. On a second case, you were arrested on a failure to appear on driving while license suspended or revoked. Bond in that case is $2,500. I will appoint the office of the public defender to represent you in that case as well. As a result of, well,
Your Honor, that first appearance detainer was closed. That was entered in error.
okay,
It's not a case that would be fatted.
perfect. Then we'll leave it as it is. Thank you.
What was that first bond, Your Honor?
The first bond?
Yeah,
100.
100. Thank you.
Next case I have would be Ritash Prasadi.
Bonded.
Keep saying that. Next case I have is Tehran Burks. Tell me your name, please.
Teron Keontae Burks.
Sir, you've been arrested on a charge of trespassing, failure to leave property on order by owner. There's probable cause for your arrest. Your bond is set at $500. I will appoint the office of the public defender to represent you. Having found probable cause in case number 2021 MM249AE, 2021 CF138288AO, 2021 MM188AE, I will revoke the bonds on all of those and set bond at $0. Appoint the office of the public defender on each case. Thank you.
Your Honor, what was that defendant's name? Defendant's name.
Burks.
Okay.
Burks.
And we left the trespass at 500? Thank you, sorry.
That's okay. I'd rather you ask than guess and guess wrong. Joseph Carland. Joseph Carland.
Yeah, he just wrote up.
Is that Joseph Carland next?
I don't have them on the list, Your Honor. Do you have the booking number for them?
Yes, 210-28187.
Excuse me, sir, I'm trying to see which ones you was talking about that are revoked.
Yes, so there's three, I believe, that you were out on bond on. Let me go over them. Hang on one second. So you understand, okay? The first one I have is, it ends in number 249, and that charge is trespass on property other than a structure. The second one I have is the felony case, which is delivery of a controlled substance within 1,000 feet of a place of worship, sale and delivery of methamphetamine and possession of methamphetamine. And the third case I have ends in 188. That's trespass on property other than a structure as well. Does that answer your question?
But these are the ones that they've already gave me like the ROR on it, and I haven't had no bond.
Well, they did, but you just got arrested for the same charge, and so I'm revoking that release.
So these are not even the charges that I'm in for. I'm talking about the one right here, the
new one.
Yes.
So the new one, the bond is $500.
So can we good to put you on this charge here before we go?
No, because you were out on bond, you were out on ROR on 3 other cases, and then you got arrested on a new charge.
And she just walked in with a plea. So it's like, if she asked me for a plea and I accepted the plea, can we still plead?
You can plead to the new one.
That's what I'm talking
about. But you have 3 other cases with no bond.
That's what I'm telling you. We can plead to this new one.
And you want the three others just to continue to remain pending? There's no benefit to
Right,
that.
then you might as well remain them pending because they've already told me that she's not even the attorney for it.
Okay.
So we might as well go ahead and plead to this other one already, so it ain't gotta be.
I'm not going to accept a plea this morning. I think you should bundle them all up and work them out together. It'll be to your benefit.
It's two different places though. It don't make no sense.
Well, to bundle them makes sense. I've been in the system for 40 years. I was a private attorney for 25 years. I was a prosecutor in the 1980s for 5 years. I've been a judge now for 9 years. I am telling you, I have experience in this. You need to bundle your cases together and work it out. To do it one at a time won't benefit you.
But this will only
Enough.
only hold him only hold me for.
No, you're being held on those 3 cases with no bond.
But I don't need charges.
You're not anymore. You're back in on them.
Come
on.
Your Honor, Carland bonded.
Okay, thank you. Next, I have Lorelei Haynes.
Yes, Your Honor.
Good afternoon. You've been arrested on a charge of trespass after warning. There's probable cause for your arrest. Bond is $500. I'll appoint the Office of the Public Defender to represent you.
And Your Honor, she wishes to resolve the case. She
Have we
wants to
heard from the
plead
victim in this
guilty.
case?
Yes, Your Honor. It's a withholding court cost, Your Honor.
Have we heard from the victim?
Your Honor, I know you mentioned this earlier. The state doesn't really consider trespass victims to be true victims. We do not typically contact them before resolving cases unless it's an individual with a home. I believe this was a place of business.
And the definition of victim under Marcy's law is somebody affected by the crime. And here,
Your Honor, it's the Central Florida Fairgrounds.
well, that would be Orange County. Okay. What's the plea offer?
A withholding court costs.
Okay. You want to enter a plea of guilty to this charge and receive a withholding court cost? Okay. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. Put your hand down. Tell me your full name and your date of birth.
Lorelei Haynes, March 13th, 1973.
Perfect. You're charged with trespass on property after warning. That's a crime that carries up to state, up to.
Looking now. The link is not working.
810.092 Bravo.
Right.
Although on another sheet it says 810.09-5.
Under 810.09-5. There is no -5.
Okay. Then look under 810.092 Bravo.
Okay.
Lowercase Bravo.
Two Bravo is misdemeanor of the first degree.
Face up to a year in jail and a $1,000 fine. And I will find that there's a factual basis based upon the arrest affidavit. I understand you wish to plead guilty to the charge and resolve this case. Is that your understanding?
Yes, Your Honor.
Has anybody forced you or threatened you to get you to enter this plea? Are you doing this of your own free will? As you stand before me now, are you under the influence of any drugs, medication, or alcohol?
No, Your Honor.
Do you suffer from or have you ever been diagnosed with any mental illness?
Mental illness, no.
Are you thinking clearly this morning? Yes. Okay. Have you had a chance to read over and sign a one-page plea form that lists all the rights you have and the rights you give up when you enter a plea?
Yes, Your Honor.
Do you have any questions about that?
No.
No?
No.
You didn't seem confident in that. Okay. But the answer is no, correct?
I don't have any questions.
Okay. To the charge of trespass, do you plead guilty or not guilty? I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I have found a factual basis. State anything before I impose the agreed sentence.
No, Your Honor.
Anything you wish to say, ma'am, before I impose the agreed sentence? I will go ahead and withhold adjudication of guilt, sentence you to 1 day in jail with credit for 1 day that you've already served, order that you pay court costs, cost of prosecution. I did not appoint a public defender, so there's no additional fee. I'll reduce that to a judgment. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll appoint one for you. Do you understand your sentence?
Yes, Your Honor.
Good luck to you. You're welcome. Kyle Click.
Bond, Your Honor.
Robert Loomis. Is that you? Tell me your full name.
Robert Prince Lewis.
You're charged with petty theft. There is probable cause for your arrest based upon the affidavit of your arrest in this case. I will appoint the Office of the Public Defender to represent you. Your bond is set at $500. I'm going to add a condition you not return to any Home Depot while this case is pending. Thank you.
Your Honor, we would just like it placed on the record that the state did offer an adjudication of guilt, court costs, 60 days OCJ. That offer is not accepted today. The state is going to be upfiling this to a felony.
Okay. Did you understand what the prosecutor said? Yes? Because I'll explain it if you didn't understand it. You understood. Okay. And do you wish to enter a plea of guilty today and receive a 60-day sentence? There's no pressure. It's totally up to you.
I mean, if you're saying that the prior is not you, then it wouldn't be, but I don't really know the decision. You wish to censor plea, Your Honor?
Okay. I'll need the file back.
Yeah, the plea form.
Sir, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Tell me your full name and date of birth.
Robert Brenton Loomis, 4489.
Okay. Your attorney there is going to hand you a plea form. It lists all the rights you have and all the rights you give up when you enter a plea. I would like you to carefully read that and then sign it after you've read it.
Yes, sir.
Did you understand all those rights?
Yes, sir.
Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
You're doing this of your own free will.
Yes.
As you stand before me now, are you under the influence of any drugs, medication, or alcohol?
No, sir.
Do you suffer from or have you ever been diagnosed with any mental illness?
No, sir.
I will find there's a factual basis based upon the affidavit of arrest in this case. And the plea offer is an adjudication, 60 days in jail with credit for 2 days that you've already served. And the alternative is not to enter a plea, and the state is indicating they'll file more serious charges or upcharge. You understand that?
Sir.
And that's acceptable to you, correct?
Sir.
Okay, then to the charge of petty theft, do you plead guilty or not guilty?
Guilty.
Thanks. Well, that was a question. I want you to answer. Okay, thank you. I will accept your plea. I'll find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I found a factual basis. State anything before I impose the agreed sentence.
No, Your Honor.
And, sir, is there anything you wish to say before I impose the agreed sentence?
Sir.
I will go ahead, having accepted your plea, adjudge you to be guilty of theft, sentence you to the agreed 60 days in jail with credit for 2 days you've already served. I must order that you pay court costs, cost of prosecution, $100 contribution for the services of your attorney. I'm going to order within 30 days of release from all incarceration, you report to the clerk's office, room 410, set up a payment schedule. That way I don't have to put you on probation just to make sure you pay it. Any questions or concerns, Madam Clerk? Anything else, State?
No, Your Honor.
Defense, anything else, ma'am?
No, Your Honor.
Okay, sir, do you understand your sentence?
Yes, sir.
You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll appoint one for you. Good luck to you.
Okay, thank you, sir.
This case, yeah, I did appoint, and I added the $100 public defender fee. Next, I have Eric Vance. What's your name?
Correct. Yes, Eric Vance.
Okay, So you've been arrested on petty theft, first degree, a crime that carries up to a year in jail and $1,000 fine. There is probable cause for your arrest. I'm going to set bond in the amount of $1,000 with a condition you not return to any Walmart because you were out on bond when you were arrested for this theft. Case number 2021 MM.
And Your Honor, that case was entered in error. The MM should not have been a first appearance detainer.
Okay,
But the 2021 CF case is correct.
thank you. Then in case number 2021 CF 5226, a charge of petty theft having 2 prior theft convictions. I will revoke the bond on that and hold you a no bond on that case and appoint the office of the public defender to represent you on both cases. Thank you.
Your Honor, the state would like to make the similar announcement on the record that in exchange for resolving this today, the offer would be an adjudication of guilt, court costs, and 60 days Orange County Jail. However, beyond today, we will be up filing this case as a felony similar to his other felony, petty theft.
Okay, 2 things. First, Mr. Vance, did you understand what the prosecutor said?
Right. Yes, I did.
Okay, do you have questions about it?
Yes, I have my grandmother sick and I just got a job. Is there any way that, because my bond was already supposed to be paid on my new case last night, is there any way that I'll take like a plea because my grandma's sick and I'm taking care of her.
But
Is there a way I can take like a
the
plea?
plea won't help you because I revoked your bond on the felony petty theft case.
Right, is there a way that we could avoid revoking my bond on the first case so that I'm able to still bond out on this one, sir?
No, you should have thought about that before you went into Walmart, right?
Yes, sir, I understand.
Yeah, I'm just not sympathetic to that.
With the plea offer,
The plea offer doesn't get you out of jail. It gives you 60 days.
60 days.
And then you still can't get out because I revoked your bond on the felony case. So it doesn't get you out of jail any quicker. But here's what it does do. It keeps the state from filing another felony charge against you, which might affect how much time you serve in the other felony cases. But it won't get you out. I don't want you to plead thinking it's going to get you out.
No.
But it might protect you from a more harsh sentence because it'll be a misdemeanor in 60 days than a felony facing up to 5 years. You want to talk to your attorney about it a little bit?
yes, please.
Yeah.
Don't you think that that's my best option because if I don't accept the plea today, fair enough, I have 2 felonies for this one today. They won't be able to add any more charges or do anything, then I'll just have to get my first one resolved and maybe they may consolidate it the time.
You're all caught up now, aren't you?
Overall time, I think
Globalize, is that a word?
Sometimes we do say that, yeah.
You should Google that. I don't think that's a word.
Sometimes we use it at the state attorney's office.
That's Miss Hicks. I guess it would be the act of making something global, to globalize something. But maybe
Hey, it is a verb. In Merriam-Webster, no less.
the vernacular that accused people come up with are great. I picked up a charge. I caught a charge. Okay, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Please put your hand down. Tell me your full name and your date of birth.
Eric Vance, May 29, 1991.
Okay, you're charged with petty theft, first degree, a crime that carries up to a year in jail and a $1,000 fine. It's my understanding you wish to plead guilty to that charge and receive an agreed sentence of 60 days in jail and the order of court cost of prosecution, and a contribution for the services of your attorney. And the state would agree not to file felony charges on this case. Is that your understanding?
Yes.
Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
And are you doing this of your own free will?
Yes.
The plea offer was just made to you this morning. Do you want more time to think about it, or do you want to go forward with it today? It's your
'Cause,
choice.
If I'm given more time to think about the plea, then that leaves the option for the state to then turn it to a felony.
It does.
Okay, so I don't want to do that. I'd rather not waste time.
And I understand. I just don't want you to feel more pressured than having that potential threat. You don't feel any more pressure than just that threat, correct?
No, sir.
Okay. You're being handed a plea form. It lists all the rights you have and all the rights you give up when you enter a plea. I'm going to ask you to sign it after you've read it. Have you signed that form? Do you have any questions about the rights you have and the rights you give up when you enter a plea?
No, sir.
Are you currently under the influence of any drugs, medication, or alcohol?
No, sir.
Do you suffer from or have you ever been diagnosed with any mental illness?
No, sir.
I will find there's a factual basis based upon the arrest affidavit in this case to the charge of petty theft first degree. Do you plead guilty or not guilty?
Not guilty.
Okay. Is that what you want to plead?
Right.
Okay. I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I found a factual basis. State anything before I impose the agreed recommended sentence.
No, Your Honor.
Vance,
No, Your Honor.
anything you wish to say, Mr. Van Sice, before I oppose the agreed sentence?
Yes. Well, I get what I'm not. I would give 1 day credit towards that, or
Yes.
And then what about the percentage of time you do? Like what I do, the full 60 days, or is there like a certain amount less?
That's a good question.
Right.
And when I was a defense attorney, I used to know the answers to that.
Okay.
So let's look to your left and ask your attorney, how much is he going to do of the 60 days?
Yes, Your Honor. So for every 30 days he serves, he should get 5 days of credit so long as he doesn't mess up any of his game time.
So let's say so you get credit after you serve the first 30 days.
That's my understanding, Your Honor.
So after the first 30 days, he'd get 5 days off. So out of 60 days, he'd serve 55 days.
I believe so, Your Honor.
I don't know anymore. I used to know.
Right.
I stopped
It
knowing.
could be more or less depending upon his
I thought it was much
classification
more
in the dorm
generous.
and everything.
I thought it was
as
much
well.
more generous. Anyway, I will go ahead and adjudge you to be guilty and sentence you to the agreed 60 days in jail, credit for time you've already served. I must order that you pay court costs, cost of prosecution, a $100 contribution for the services of your attorney.
Okay.
Rather than put you on probation, I'm going to order within 30 days of release from all incarceration, you go to the clerk's office, room 410, and set up a payment schedule. That way I don't have to put you on probation for this. I'm also going to order that you not return to any Walmart. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, of course, I'll appoint one for you. Good luck, Mr. Van Sice.
Thank you.
Next case I have is Richie Vergara.
Bonded.
The next case I have is Jerica Decker. Is that you? You've been arrested on a warrant from out of county. It indicates that bond is $4,500. I will appoint the office of the public defender to represent you. Thank you. This case I have is Anthony Raymond. That was a mental health yesterday. Anthony Raymond?
It's Anthony Lamar. I'm sorry, it's Raymond Anthony Lamar.
Oh, boy, okay. How about Raymond Anthony Lamar? Still? Okay, I will appoint the office of the public defender to represent him. Would you like to waive his appearance?
Yes, Your Honor.
His appearance having been waived, I will find probable cause under disorderly conduct, leave bond at $500.
Your Honor, if I may be heard.
Yes.
A case in front of Judge Bigney was just dismissed on November 30th, 2021, finding him incompetent to proceed.
Your Honor, let me look into that real quick because sometimes they don't. Let me just see how old the competency evaluation is.
Yes. Why don't you take a gander?
The confidential evaluation was completed on February 4th, 2021.
Okay. So then it is, in this court's opinion, no longer timely because it's more than 6 months old, notwithstanding Judge Bigney's release on November 15th of this exact individual. So I will go ahead and leave bond at that amount, and I will revoke the releases in 2021 MO 777 and 2020 MM 8625. Set the bond at none and let Judge Bigney get updated evaluations of that. I will appoint the Office of the Public Defender in order to make sure we get updated evaluations so that this individual, if he's still incompetent, can be released and we can attempt to get him help. Next case I have is Marcellus Clark. You, Mr. Clark?
Yes.
Good afternoon.
How you doing, sir?
I'm doing fine, thank you. Nice haircut you have. You've been arrested on a charge of disorderly conduct. I will appoint the, I won't appoint the Office of the Public Defender, but how would you like to proceed, Public Defender?
Yes, Your Honor. I've spoken with Mr. Clark. He's indicated he wishes to plead guilty and receive the agreed upon disposition of withhold court costs and credit for time served.
Is that what you wish to do, sir?
Yes.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Put your hand down. Tell me your full name and date of birth.
Marcellus Clark, April 6, 1958.
Okay, that's a good year, right?
Mm-hmm.
You've been charged with disorderly conduct. There is a factual basis for your plea. It's my understanding you wish to plead guilty to this charge and receive an agreed sentence that I am willing to go along with. Is that your understanding?
Yes, sir.
Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
Doing this of your own free will?
Yes, sir.
Are you under the influence now of any drugs, medication, or alcohol?
No, sir.
Do you suffer from or have you ever been diagnosed with any mental illness?
No, sir.
Have you had a chance to read over and sign a one-page plea form that lists all the rights you have and all the rights you give up when you enter a plea?
Yes, sir.
Do you have any questions about those rights?
No, sir, I don't.
To the charge of disorderly conduct, do you plead guilty?
Yes, sir.
I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I found a factual basis. State anything before I impose the agreed sentence.
No, Your Honor.
Sir, is there anything you wish to say before I impose the agreed sentence, Mr. Clark?
No, sir.
I will go ahead and withhold adjudication. I must order that you pay court costs, cost of prosecution. I did not appoint the public defender. I'll reduce it all to a judgment. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll appoint one for you. Good luck.
Thank you, sir.
Next case I have is Austin Lamb.
I don't.
210-28185.
They bonded, Your Honor.
Okay, will you say that 2 more times? The penultimate case I have is Stephen McCarter. Is that you?
Yes, sir.
Good afternoon. You've been arrested on a charge of camping. There's probable cause for your arrest. Does he qualify for pretrial release?
No, Your Honor, he does not.
Does he want to enter a plea of guilty and resolve this case?
I didn't have an offer.
Yeah, Your Honor, I erroneously didn't give an offer on this case. The state's offer is a withholding court costs.
You want to enter a plea of guilty and receive a withholding of adjudication of guilt and court costs reduced to a judgment?
Take it out today.
Yeah. Yes, sir.
Okay, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
Please put your hand down. Tell me your full name and your date of birth.
Stephen Christopher McCarter, 8/28/86.
Okay, you're charged with camping, a violation of City Ordinance 43.52. It's my understanding you wish to plead guilty to that charge and receive an agreed sentence of 2 days in jail, credit for 2 days you've already served, and payment of court costs, cost of prosecution, reduced to a judgment. Is that your understanding?
Yes, sir.
Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
Doing this of your own free will?
Yes, sir.
Are you signing a plea form that lists all the rights you have and all the rights you give up when you enter a plea?
Yes, sir.
Do you have any questions about those rights?
No, sir.
To the charge of camping, do you plead guilty or not guilty?
Guilty.
I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and I found a factual basis. Anything you want to tell me before I impose the agreed sentence?
No, sir.
I will withhold adjudication of guilt, sentence you to 2 days in jail with credit for 2 days you've already served. Order that you pay court costs, cost of prosecution, reduced to a judgment. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, sir, of course, I'll appoint one for you. Good luck to you. The last case I have for December 5th, 2021 is Gregory Spruill. Is that you?
Yes, sir.
You're charged with alcoholic beverage open container. If you'd like to plead guilty, what's the plea offer?
A withholding court cost, Your Honor.
Okay, is that what you wish to do, Mr. Spruill?
Yes, sir.
Raise your right hand. You swear to tell the truth, the whole truth, nothing but the truth.
I do.
Put your hand down. Tell me your full name and date of birth.
Gregory Spruill, 3156.
Okay, it's my understanding you wish to plead guilty to possession of open container and receive an agreed sentence of a withholding of adjudication, payment of court costs, reduced to a judgment in violation of City Ordinance 3306. Is that your understanding?
Yes, sir.
Has anybody forced you or threatened you to get you to enter this plea?
No, sir.
Doing this of your own free will?
Yes, sir.
As you stand before me now, are you under the influence of any drugs, medication, or alcohol?
No, sir.
Do you suffer from or have you ever been diagnosed with any mental illness?
Yes, sir.
Tell me what that is.
It was a schizophrenia type.
Okay. Do you normally take medication for that?
Yeah, I took it, but I haven't took none since I came back from Chicago.
How long ago was that?
Oh, it's been about for the holiday time before Thanksgiving. I think it's been like I've been back here maybe a month.
So let me ask you. You're not on medication. You have schizophrenia. Are you thinking clearly this morning?
Yes, sir.
Are you understanding everything I've said?
Yes, sir.
I'm going to note for the record you're making perfect eye contact with me. You're answering me appropriately and politely, and I too believe you understand what's going on. To the charge of open container, do you plead guilty or not guilty?
Guilty.
I accept your plea. I find it's freely and voluntarily given after you told me you understand the rights you have and give up when you enter a plea, and that I have found a factual basis, and I will find a factual basis based upon the affidavit of arrest that I reviewed. Anything you wish to say before I impose the agreed sentence?
No, sir.
State anything else?
No, Your Honor.
I will go ahead and withhold adjudication of guilt, sentence you to 2 days in jail with credit for 2 days you've already served. Order that you pay court costs, cost of prosecution, reduce all that to a judgment. You do have 30 days to appeal. If you wish to appeal, it must be in writing. If you cannot afford an attorney, I'll appoint one for you. Good luck, Mr. Spruill.
Thank you, sir. Your Honor.
Next case.
Your Honor, I have one question. I had a note on James Jeremiah Vila that he was reset to today.
Yes.
But he wasn't on our reset list.
We called him.
We did?